Have you ever been faced in your business with non-payment? Have you ever had a customer or a client just refuse or flat out not pay you for the work or the services that you've performed? This is frustrating and it can be devastating for your business. I mean, your business runs on revenue. You expect that if you do a project, that if you do the work, that you're going to get paid for it. So what happens if you're not paid? Now, most of the time, most clients, most customers, they're going to pay you. They'll pay you what you agreed upon. They're going to pay you timely or within a pretty quick turnaround, but there's going to be that 5% or so that just aren't going to pay or that are going to make payment impossible or at least difficult. So the first step in what we typically recommend that a business owner does in order to accomplish payment is send a demand letter. That's just a letter stating that here's the amount that we're owed, this is why we're owed it, and you have within a certain amount of time to pay it. Now that time frame could be within the contract, that time frame could have been upon a verbal agreement, but whatever it is, set a deadline on when they must respond to that demand letter. If they don't respond to the demand letter, we'll consider mediation or arbitration. Those both can be good alternatives to going into a lawsuit or going to court. And a lot of times, many contracts require mediation or arbitration first. So if you have a contract, check that contract to see if it requires that you initiate mediation or arbitration before filing a lawsuit. You do not want to file a lawsuit if you have a contract that requires that, because it can really risk your claim and perhaps even have your claim dismissed if you don't file the proper process to go through arbitration or mediation. Now, if you don't have that provision in your contract, or you've already satisfied that requirement and you need to file a lawsuit because you haven't been paid yet, then be prepared. Hire an attorney that knows what they're doing, that knows the issues, that is familiar with your contract, and then can pursue it for the right remedy and the best outcome possible. So speak with an attorney that is either has experience in business, that has experience in litigation, that knows the best course of action, the right venue in order to pursue and protect your claim for payment on the services that you rendered. And then most importantly, always have a written contract. Let me say that again. Always have a written contract. All too often, I see business owners like you who are great people. They trust people just like I do, but you need to have it in writing so that if something does go wrong, if something does go sideways in the deal, that you have options. And your options are going to be much better, much stronger if you have a written contract. And not every contract is a good contract. So make sure you have a well-written contract with provisions in that contract that protect you, that allow you to recover attorney's fees, and that give you the best possible outcome of winning in court. So if you have any questions, if you're faced with an issue where your customers, your clients aren't paying the bills that they agreed to pay, feel free to give us a call, shoot us an email, check out our website, McCormickPC.com. We're gonna post a detailed written blog on this topic. And best wishes, best luck for your business, and we look forward to talking and working with you. Thank you.